convene and the Senate Judiciary Committee will come to order. We were discussing a few things as we were preparing for the meeting this morning, so I apologize. We are not getting started right at 10:30. But with that, then, we will ask for requests for bill introductions. Do we have any requests for bill introductions from the committee? Seeing none, do we have any from folks in the committee meeting room? Yes, Ed Klump, please come to the podium and introduce yourself. Welcome back to committee.
Thank you, Madam Chair. I'm Ed Klump, and I'm here today with two bill requests on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. The first one is a reincarnation of Senate Bill 133 from 2020. It's a bill that deals with disposition of property that we seized. It passed out of this committee favorably, but didn't get above the line. And the proposal that we have is the bill exactly as it was amended by this committee in 2020. And that RS number is 22 RS 2677.
Thank you. The bill will be introduced.
Okay, and my second one is 22 RS 2685. This is a bill amending the burglary statute. This comes to our attention through a appellate court case, State versus Glover, several years ago, in which it was a case where a person had entered a Catholic church that was open to the public for prayer, but while there, they forced entry into a locked room and stole items. And the court said in their ruling, interestingly, they said if this interpretation is not what the legislature intended, the law could be changed to morally and clear subunits of a building as being buildings or structures. And that's what this bill does. It proposes changing the language so that a subunit within a building that a person enters lawfully, if they can't enter that room or section lawfully, it would still be a burglary.
Thank you, and the bill is deemed introduced.
Thank you.
Thank you. Any other persons in the committee meeting room? Yes, sir, please identify yourself and welcome to committee.
Hello, my name is Bill Rowe. I'm with Attorney General Schmidt's office. I'm a senior advisor, and we have three bills. Thank you for the opportunity to request this committee to introduce the following bills on behalf of Attorney General Schmidt. RS 2655, bill concerning the Kansas Offender Registry. The bill will require individuals convicted of internet trading in child pornography and aggravated internet trading in child pornography to register as sex offenders.
Thank you. The bill is deemed introduced.
RS 2656, a bill concerning domestic violence offenders assessments. This bill would require courts to order domestic violence assessments for first-time offenders convicted of domestic battery and authorize courts to provide certain documents to the batterer intervention program conducting the assessment.
Thank you. The bill is introduced.
RS 2691, a bill concerning the rules of evidence. This bill would require courts to allow certain persons with specialized training to testify on the issues of impairment.
Thank you again. The bill is introduced.
Thank you for considering the requests. I'd be happy to stand for questions.
Seeing none, then thank you very much for coming over today.
Thank you.
Any other requests for bill introduction? Any requests for bill introduction from those attending online? Seeing none and hearing none, then we will turn to the next order of business on the agenda, which is we will open it up for hearing on House Bill 2477. And as you recall, we heard informational presentation about the executive orders of 22-01 and 2202 regarding certain provisions allowing certain healthcare providers to practice a little bit differently in the few coming months. So with that, then we'll ask for, from the reviser, a bill brief. Thank you.
Thank you, Madam Chair, and good morning, everyone. Scott Abbott with the Office of Reviser of Statutes again. House Bill 2477 would codify those two executive orders, 2201 and 2202, into statute for a period of time. Those EOs, as you heard last week, were issued on January 6th of 2022 in conjunction with the state of disaster emergency. So the bill in Section 1 would contain the provisions of EO 2202. This would suspend a number of licensure and other requirements for adult care homes. Specifically directs KDADs and any regulatory authority under KDADs to extend renewal deadlines for continuing education requirements, to issue temporary licenses to those who have lapsed within the previous 5 years, and to waive late fees that are associated with any of those extended or temporary licenses. Additionally, allows for temporary aid authorization for persons to work in adult care or nursing facilities as set forth by the agency, subject to specific minimum requirements, as well as temporary authorization for persons who have not previously been licensed, subject to minimum requirements, and also limiting those persons to care only for individuals who require minimal supervision or assistance, so only in those circumstances. The bill would also amend the procedure for provisional licenses for adult care homes. Adult care homes are able to get a provisional license if they are temporarily unable to strictly comply with all of the statutory requirements. The bill would amend that process for a time to allow for these provisional licenses to be issued without the normal requirement for state fire marshal approval if the adult care home submits a checklist and a plan for the isolation and cohorting for COVID-19 within the adult care home. Section 2 of the bill would contain the provisions of EO 2201. This would also renew the provisions of KSA 48966. In the 2020 special session, the legislature codified the provisions of that executive order that expired on March 31 of last year. So Section 2 of the bill would renew those provisions until March of this year. May, I forget the date, sorry. But it would include provisions related to the practice and licensure of a number of healthcare professions for a time. Think many mid-level practitioners, think many categories of nurse, pharmacists, physical therapists, students in medical or other healthcare programs, and qualified volunteers. Would allow them to perform some additional tasks without the normal supervision requirements imposed by statute or regulation during that time. Would also allow for a healthcare professional licensed in other states and in good standing to practice in the state of Kansas, subject to any license limitations that already exist on their license in the issuing jurisdiction. Would provide for liability protection for them in civil, criminal, or administrative proceedings. The bill would amend that statute to add two clarifying technical kind of provisions. First, to provide that the statute does not authorize the practice of any profession that is not already authorized by law in the state of Kansas. So if there is a profession that is allowed in another state, they can't come to Kansas and practice that profession here if it's not already authorized by law. And second, that the statute does not supersede or waive the jurisdictional authority of any regulatory agency in the state of Kansas. Additionally, it includes provisions for those whose license have lapsed within the previous 5 years to be renewed, reinstated, licensed, or certified without meeting some of this regular statutory or regulatory requirements for examination if the exam was canceled during the state of disaster emergency, or in this case while the bill is in effect, fingerprinting, continuing education, and the payment of any fee. Professional certifications in life support, advanced cardiac life support, and first aid remain valid while the section is in force and effect, and fingerprinting requirements for individuals as a condition of licensure for any hospital, nursing home, county medical care facility, or psychiatric hospital are also temporarily suspended. There was a technical amendment by the House Committee of the Whole. There were two references in the underlying bill as introduced that referred to the original 2020 state of disaster emergency. Those references were not corrected in the introduced bill, so those references were updated to refer instead to while this bill would be in force and effect. So through its expiration date, those were simply outdated references from the bill that you all passed in the 2020 special session that needed to be updated. So the House Committee of the Whole did do that. So, Madam Chair, those are the provisions of the bill. I would be happy to stand for any questions.
Thank you. Committee, any questions? Seeing none then. Committee, any discussion on the bill? Yeah. Senator Thompson.
Thank you, Madam Chair. Well, it looks like we've got some proponents to testify. I'll withhold any questions until after that.
Yes, thank you. With that, then, we will introduce our first proponent with in-person testimony, Rachel Monger, Chief Advocacy Officer, Leading Age, Kansas. Please introduce yourself and welcome to committee.
Thank you so much, Madam Chair. I am Rachel Monger with Leading Age Kansas, and we are the state association for nonprofit and faith-based long-term care in Kansas. And we are here in full support of the extension of Executive Orders 2021 and 2022, and we appreciate that the legislature is willing to look at alternate routes to preserving very badly needed workforce flexibilities in healthcare. If you've talked to your nursing homes back home in the last year, you already know how dire those staffing shortages are, and that was pre-Omicron. Now I'm back to receiving calls daily from nursing home administrators telling me that their already meager workforce is being sidelined by the dozens due to new positive cases and exposures. And they're calling me, asking me what options they have left to keep residents safe. And before these recent executive orders, I didn't have a lot to tell them. The regulatory flexibilities restored to us in the governor's executive orders are the same ones we had through the beginning of the pandemic. They are not a cure-all, but they are a lifeline, and it's a lifeline that our providers and residents desperately need right now. Extending the EOs until at least mid-May allows adult care homes to weather the chaos of Omicron and to work with legislators on some longer-term solutions to tackle our ongoing staffing challenges. You all have done a lot for senior care providers, but more importantly for seniors during this pandemic. And we really are grateful for the opportunity to come back here today and continue that work by passing House Bill 2477. So thank you for that, and thank you, Madam Chair, and I'm happy to answer any questions.
Thank you, and we will address all the questions after we've had all the proponents testify. So thank you very much for that. Next, we will hear from Linda Mowbray, President CEO of Kansas Healthcare Association. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, and thank you. I am Linda Mowbray. I'm the President CEO of Kansas Healthcare Association and Kansas Center for Assisted Living. We're a trade association statewide that represents nursing homes, assisted living, home plus, residential health care, adult daycare. We have for-profit and not-for-profit members. And I come here today to say thank you for taking up this issue. We are grateful that you are looking at lifelines for our homes. Since the COVID epidemic started, we've had staffing issues. We have had people leave the industry. We have had, we just think we're coming around the corner and then boom, Delta. And we think we're coming around the corner again and boom, Omicron. So to have you look at extending the executive orders, the 2201 and 2202, it really is a lifeline for our homes as we struggle to get through this next wave. The provisions in this bill that allow for the use of temporary nurse aides is something that some people will tell you, well, they shouldn't be able to do that. It did work before. These individuals went through a training program through the American Healthcare Association, which were part of their federation. The training then requires 2 additional hours within the home, and then supervision. So what this means is that individuals that go through the temporary aid program, they may not work at the full capacity of a CNA. They may come out and help with dining. They may help someone get from the table back to their room in their wheelchair if necessary. They are not necessarily going to be giving showers or taking people to the restroom unless their supervisor feels like it's necessary. Thank you for supporting and listening to the testimony. House Bill 2477 is a good piece of legislation that will help us get through this. I'll stand for questions at the appropriate time.
Thank you very much. That's all we have written on the agenda for proponents in person, but I will ask, are there other proponents who want to give oral testimony today in the committee meeting room? Yes, I see. Yes, please introduce yourself and welcome to committee.
Hi, Madam Chair. I'm Tara Mays with the Kansas Hospital Association. I appreciate the opportunity to appear before you. I have provided written testimony as well as appearing before you last week when you had your informational testimony. I don't have any new updates to provide to you all, but I just wanted to echo the comments of my colleagues that have been made here today. Our hospitals are really focused on getting through these next couple of months, and as you heard last week, the staffing shortages are taking a toll. And while we know House Bill 2477 won't solve all of those problems, it is a very much needed help at a critical time, and we can't thank you enough for your expedited look at this piece of legislation, and you're taking a look at how critical these provision extensions might be for the healthcare industry and for the citizens that are utilizing those services right now. Appreciate the opportunity to be here. Happy to stand for questions.
Thank you, and we did have you under written proponent, but thank you for coming up and testifying as well, and apologize we didn't have that in the right spot there. Any other in-person proponents who would like to give testimony today who are in the committee meeting room? Seeing none, are there any online? Great, thank you. Seeing and hearing none, then we will ask for committee members to look in your committee packets. You will see written proponent testimony from Haley Ordoin, Chair of the Kansas Adult Care Executives Association, as well as written testimony, proponent testimony from Jim Clausen, CEO, Midwest Health Incorporated. We then have neutral testimony in person from Courtney Seisman, General Counsel of Kansas State Board of Healing Arts. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Courtney Seisman, and I'm General Counsel of the Kansas State Board of Healing Arts today, and thank you for the opportunity to present to you testimony today regarding House Bill 2477. A little bit about the Board of Healing Arts. We are the executive body that is tasked with licensing and regulating many healthcare professions in Kansas. Several of these are frontline healthcare workers, physicians, respiratory therapists, and physician assistants. The board itself is made up of 15 members, 12 of whom are licensed healthcare professions in Kansas, and 3 of whom are public members. The board's statutory mission is to protect the public, so anything it does, any decisions it makes, the testimony that we provide you guys, it's through the lens of thinking, are Kansas patients going to be safe? There are many aspects of the bill that's before you today that the board supports, including the temporary regulatory flexibility to facilitate the state's response to the COVID-19 pandemic. The board also believes it's its duty to point out some legal substantive provisions of this bill that present some public safety concerns. And the board respectfully requests that the legislature amend the bill in a manner that retains the board's ability to protect public safety. The first and main concern of the board is in Section 2 at subsection H. Right now, as written, this subsection does not allow for these healthcare professionals to be licensed. And the way that the Kansas State Board of Healing Arts or any healthcare regulatory body has jurisdiction to take some form of legal remedy if something goes wrong is with a license. The amendment that is currently in there right now as proposed in terms of making sure that state law is not superseded by having jurisdiction is certainly an improvement. However, without clarifying that individuals who come in and work in Kansas under this provision are in some way deemed a licensee for purposes of the Applicable Practice Act, the jurisdiction's not there. Another key portion of this section that is of public safety concern is right now this subsection is not limited in any scope in terms of the COVID-19 pandemic. it includes services that are completely unrelated to the pandemic. So a provider could come in from out of state without letting anyone know that they're here and, you know, provide Botox or something completely unrelated to COVID-19. So as a potential fix, the board recommends an amendment that is included on page 2 of my written testimony, that in subsection 2H, we include a provision that ties this to the purpose of COVID-19. And so the first sentence would read, notwithstanding any statute to the contrary, a healthcare profession licensed in good standing in another state may practice such profession in the state of Kansas for the purpose of preparing for, responding to, or mitigating any effect of COVID-19.
Could I stop you right there? I do not see written testimony in our committee packet. Have you submitted that and turned that
I did
in?
submit them last night. I do have written, or I have printed out copies that I can hand out.
If you could, please. Thank you.
Okay, so that is found on page 2. The other, and that amendment would narrow this to healthcare professionals coming in providing services in response to COVID-19. And that language is quite broad, so it would certainly address the staffing issues that lately have been a direct result of COVID-19. The second portion that we would like amended is an inclusion of a provision that such healthcare professionals shall notify the applicable regulatory body in Kansas that they're practicing in Kansas pursuant to this provision on a form created by such regulatory body within 7 days of initiating practice in Kansas. Any healthcare professional practicing in Kansas pursuant to this subsection shall be subject to all the rules and regulations pertaining to the practice of licensed profession in the state and shall be considered a licensee for purposes of the Professional Practice Acts administered by the applicable regulatory body. So in subsection 2H, healthcare professional is not defined, so it could reasonably include more than healthcare professions that are under the board's jurisdiction. But with the inclusion of this amendment, it would allow for healthcare professionals practicing pursuant to this subsection to come in and start working immediately in Kansas, but let the regulatory body know that you're here and that you're complying with the provisions of 2H and that you're going to be treated as a licensee. So that way, in the event that something does go wrong, the regulatory body does have a legal remedy to either remediate that healthcare professional or have them stop practicing so that we protect other Kansas patients. I wanted to talk about a couple things that currently exist in Kansas law that that are accessible to healthcare professionals and can help with the staffing shortages. The free temporary emergency license was originally authorized in Executive Order 2008, but is now in law in KSA 48965. Since the creation of this at the beginning of the pandemic, we have issued 330 emergency temporary licenses. This is available for all healthcare professions that the board licenses and regulates, so long as you have a clean license in another state. It's free. These licenses are issued with a complete application within 3 business days. Kansas also now has a permanent telemedicine waiver. There was a temporary one that originally came about at the beginning of the pandemic, but it is now codified in law in KSA 6528-135. And since the creation of it, when it was temporary, we issued over 6,500 of these, but since it became permanent, we now have 92. These, for telemedicine waivers, again, you have to have a clean license in another state, apply for it, and these are issued within 3 business days, and it's limited to solely providing telemedicine to patients who are located in Kansas. And then there's the Interstate Medical Licensure Compact, which is the Physician Licensure Compact, and this allows for expedited licensure for physicians. So if a physician works and is licensed in another member state, they're able to quickly apply for a license in Kansas because we are a compact member state, and these are issued very quickly through this compact. We did also create a form at the end of this year that explains all the licensing options for the healthcare professions that we regulate so that medical healthcare facilities can use it strategically in their response to the COVID-19 staffing shortage. And that is available on our website. The board's second concern is that Section 2, subsection J. This language as written right now could reasonably be interpreted to require that the board issue renewals and reinstatements without charging any fee. If this interpretation was ever accepted by the courts, this would completely eliminate the revenue of the agency. Our agency is solely fee funded. So as a potential fix, we recommend deleting subsection J4 or alternatively creating an exclusion for solely fee-funded agencies. These fees are critical for us to maintain our operations in our regulatory function of healthcare professions to protect Kansas patients. And I'm happy to stand for questions at the appropriate time.
Thank you. The chairman had to leave the room. Are there any questions from any of the conferees that we've heard? Yes, Senator Baumgartner.
Thank you, Mr. Chair. Oh, Mr. Vice Chair. My question is actually for you. So in public health and wellness, we've had several days of hearing with regard to anesthesiology assistants, which are not licensed in the state of Kansas. So with this bill, what is your interpretation with regard to them practicing in the state of Kansas?
So, as we stated in that hearing, the board has made the conclusion that anesthesiologist assistants are authorized by law pursuant to KSA 68-127 and KSA 2637B 26 and 30 to practice in Kansas. If the legislature wants to make a policy decision, they could further clarify this in the bill as proposed.
No, answer my question. With this bill, they are not licensed in the state of Kansas. So with this bill, would they be legally able to practice in Kansas?
In our opinion, they are authorized by Kansas law right now to practice in Kansas.
But they are not licensed in Kansas.
They are not licensed in Kansas.
So when you talked about the consortium and so forth with regard to those that are already licensed, they are not licensed.
They are not licensed in Kansas.
So what is your answer? Would they be able to legally practice in Kansas or not?
They are legally able to practice in Kansas under the statutes I cited.
Not as licensed.
Not as licensed, right. So what the amendments we're asking for would create licensure. So if the legislature wants to create a policy decision, they can further clarify it within this.
I think the legislature kind of made it clear 2 years ago and several years before with the pieces of legislation that came before us that we did not want them to be licensed in Kansas. And so you can't understand how so many people feel as if your governing body bypassed the legislative process. You do understand that.
I hear your concerns.
So you are saying that with this bill, though not licensed, though there is no licensed position for AAs in Kansas, they could practice legally.
In this bill, in H1, it says authorize a healthcare profession to practice a profession that is not authorized by law in the state of Kansas. So if that is licensure, there could be an amendment that it's tied to licensure, and that would be clear, because right now it's a bit ambiguous.
Thank you. That's what we needed to know, that it does not make clear that it must be an already recognized licensed profession in the state. Thank you.
Thank you. I'm sorry I had to step out for a minute to get a few updates, and are we then in questions for, yes, for Senator Haley, from Senator Haley, thank you, and then Senator Thompson.
Thank you, Madam Chair. Thank you, Mr. Vice Chair, for recognizing me. And this is on a fast track, as we know, and I was curious as to why the House, I make the assumption, or can we assume that you have made these representations to the House as well, and that they had an opportunity to review the merits of the discussion and just did not opt to add it to the bill. Is that a fair and accurate assessment of what's occurred or what has
Yeah, so
gone
let me
procedurally?
provide a little bit of context. Actually, since the executive order came out at the beginning of the pandemic, with respect to this particular subsection, the board has always had issue with it because there's no jurisdiction, so we've been raising it constantly. With most recently, I did testify at House Judiciary regarding this, and yesterday on the House floor, Representative Kincannon proposed a few amendments that were later withdrawn.
So, Madam Chair, if we were then to consider and to amend the bill, given the exigency of the circumstance, it could be problematic in that the House has already considered and has opted to not add the language that you're proposing.
I believe it could be resolved in conference committee, and I would defer to you guys on that process.
Okay. Thank you. Thank you, Madam Chair.
Thank you. Senator Thompson.
Thank you, Madam Chair, and these are also for you, Courtney. Prior to COVID, there were staffing shortages in hospitals developing and certainly in these nursing homes. And with the advent of COVID and all the distortions in how healthcare has gone, we've seen nurses stretched thin. Now with the vaccine mandates, some quitting, doctors who were unable to prescribe preventative measures, and it's distorted the entire system. How is extending an order like this going to solve those problems?
Ms.
It's
Seisman, go
going to
ahead.
help in this emergency time. I agree there was certainly staffing shortages before, and probably for a while. But this is going to allow for, when surges are happening elsewhere, or when they're happening here, other providers in other states can come here quickly and safely and get this temporary, either the emergency temporary license or work pursuant to this provision. And we're just sort of triaging right now.
If I could follow up, Madam Chair, doesn't this, though, continually open the door to a flood of less qualified people or people who are not as fully trained?
Part of what we're trying to do is to make sure that there's not a floodgate opened. And so having this licensure mechanism in case for a limited time period is critical. Outside of COVID, and hopefully this will end at some point, that's what the normal licensing structure is there for.
Sounds to me, however, like what we're doing is putting increasing pressure on supervisory staff to make the decisions and removing any, or certainly raising the hurdle for any potential claims for malpractice or negligence.
Right, and this is why it's critical to do it in Kansas law to retain that.
Okay. Thank you, Madam Chair.
Sure. Committee, further questions either for the Kansas State Board of Healing Arts or any of our proponent conferees today? Yes, Senator Gossage.
Thank you, and thank you for being here. You've presented a lot of information that I've been rereading and rereading to try to digest. You do understand that this emergency was for the next couple of months. I know there's been some discussion of making that in March as opposed to in May. And so what I'm hearing you say, and correct me if I'm wrong, is that this extension, though short, is still an issue, and are you concerned that it will continue beyond that?
We are
Could you, hold on just a second, please. Please, before you speak, identify yourself and who you're with for those who are following along online. Thank you.
I'm Courtney Sisman, General Counsel of the Kansas State Board of Healing Arts. we are absolutely fine with the extension to May 15th of these provisions. I would caution going a lot out beyond that because we don't know where we're going to be. And outside of COVID or an emergency, there is the normal licensing structure for all healthcare professions that exists. So we're fine with extending it, and the emergency temporary license is actually set to expire March 31st. So we are fine with the extension of that till May 15th as well.
Okay, so then, if I may, Madam Chair, so you're fine with the extension, so basically you're fine with the bill? No.
No, we're
So-
not fine with the bill in terms of the time frame.
Okay.
The time frame provision of May 15th, 2022.
So some of the provisions in here are amendments that you would suggest?
Correct,
But
and
not in an
specifically on
amendment
page
form.
2.
Okay.
I think it's actually page 5 of the bill, and
Of the
it's
bill. Oh,
section 2.
My apologies, page 2 of my written testimony
go.
has my apologies.
Where it says potential fix.
Yes.
Thank you, Madam Chair.
Committee, other questions? All right, seeing and hearing none then, we do not have any, thank you for your testimony and for appearing in committee today. Do we have any opponent conferees? We don't have any submitted on the agenda, but just wanted to check if there were any in the committee meeting room or online. Seeing and hearing none then, we will then close the hearing on HB 2477 and refer committee to the written testimony also in your packet, and open up the bill for final action, for working and final action. It is an expedited process, an expedited calendar for this bill. As you know, the executive order is set to expire this Friday, January 21st. So we have heard from the reviser that the proposed bill essentially mirrors the executive orders, and this would extend the date in the bill to May 15th of 2022. I did look on the legislature website and see that the House passed the bill 106-5. So with that, then we will work the bill, and any discussion on the bill or any amendments. Yes, Senator Corson.
Thank you, Madam Chair. I do have an amendment to offer that speaks to some of the testimony we heard from the Board of Healing Arts, and Mr. Thompson has that for the committee to consider. Thank you, Madam Chair.
Thank you, and we will then ask the reviser to explain the amendment once we all have it in hand.
Thank you, Madam Chair. Scott Abbott again, Office of Reviser of Statutes. The substance of the amendment begins on page 3 of the bill. This would insert an amendment to KSA 48965, referred to earlier as the temporary emergency license provisions of the State Board of Healing Arts. You can see the copy of that statute on the last page of the amendments. The purpose of that amendment is only to extend that statute is set to expire on March 31 of this year. The amendment would extend that to May 15 of this year. The second substantive provision of the amendment is on page 5 of the bill. This addresses many of the concerns raised by the State Board of Healing Arts. You see the first box on that page adds the limiting language to these out-of-state healthcare professionals only for the purpose of preparing for, responding to, or mitigating any effect of COVID-19. It strikes that second paragraph, the clarifying language of not superseding, affecting, or waiving the jurisdictional authority, and then inserts a block of language that accomplishes a few things. First, it requires the within 7 calendar day notice to the regulatory agency that an out-of-state healthcare professional is practicing under these provisions in the state of Kansas, requires that to be on a form and in the manner prescribed by the regulatory agency. It additionally provides that any healthcare professional who is practicing under these provisions is subject to all rules and regulations that are applicable to the practice of that profession in this state, and additionally provides that they are considered a licensee under Kansas law for the purposes of the applicable professional licensure practice and licensure acts administered by the applicable regulatory body. The next change is, you can kind of see the beginning of it on the bottom of page 5, but it actually happens on page 6. This strikes the suspension of fees for these persons whose license have lapsed during the effectiveness of this section. And that is the end of the amendment, other than technical changes to the title and repealer to accommodate the added statute.
Thank you. Committee questions for the reviser? Yes, Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Abbott. I think the substance of the amendment is clear and would clean it up quite a bit. I am more concerned, or as concerned, with procedure right now, again, considering the time frame we're under. Was this language presented either in the House Judiciary Committee and/or the Committee of the Whole? Was it this language or something materially different from what you've given us?
Mr. Abbott?
Madam Chair, Senator, this amendment has not been offered before. I will say that the State Board of Healing Arts also testified at the House Judiciary meeting that considered this bill. They raised many of the same, maybe all of the same concerns, including the suggested language that is largely represented in this amendment. But this document itself has not been considered.
So, Madam Chair, Mr. Abbott, was there any codified written amendment before either of those committees, the Judiciary or Committee of the Whole on the House side?
Mr. Abbott, could you make sure you speak into the microphone so those online can follow?
Again, this particular document was not presented to the House Judiciary Committee. There was an amendment that was offered but withdrawn on the House floor that addressed some of these same issues, but not in the identical way that they are addressed in this amendment. Some of the jurisdiction issues, the fee issue, those were addressed in that House floor amendment that was withdrawn. But again, it was not identical to this document that you have before you.
Thank you, Mr. Adams. Thank you, Madam Chair.
Yes, Senator Corson, did you want to add comments to the amendment, or is there any further discussion?
Oh, I appreciate that, Madam Chair. No, this was just an attempt to try to address some of the concerns that we heard from the Board of Healing Arts, and again try to address those as we move forward, understanding the time urgency. And thank you, Madam Chair.
Thank you, committee. Any discussion further on the amendment? Seeing none, do we have a motion on the amendment? Yes, Senator Wilborn.
Thank you, Madam Chairman. Since we're trying to expedite this, to move this amendment and the bill forward, I will second the amendment. We have evaluated the language and we're content with it, with the exception of possibly some discussion in conference on that licensure. So I second the amendment.
That was just the motion. Do we have then a second, or did you move it, or?
Yeah, and I would move my amendment.
And then we have the second from you, Senator Wilborn. Thank you. Committee then, any discussion on the motion? Yes, Senator Baumgardner.
Thank you, Madam Chair. As I expressed earlier with my questions with the General Counsel for the State Board of Healing Arts, I think that we do need to hold the line that we are only going to recognize those that are currently, those licenses that are currently allowed in the state of Kansas. Those that have been allowed in the state of Kansas through the legislative process. So what I do not want us to do is by fiat, because we are in the midst of COVID, suddenly AAs will become de facto licensed professions in the state of Kansas. Because quite frankly, the one thing that we have had a significant reduction of in the state of Kansas is surgical procedures. So the last thing we need to do is flood the state with those folks that are not licensed because that hasn't been passed in the legislative process. Thank you, Madam Chair.
Thank you. Could I have clarification from the reviser that the bill is currently written, if the amendment passes, the bill states that only licenses currently recognized and allowed in Kansas we're keeping the status quo, or does that change it a bit?
Madam Chair.
Yes, Senator Baumgartner.
Just really quickly, while you were out of the room, council did indicate that because of the action that the State Board of Healing Arts took this summer, that it's not a recognized licensed profession in the state of Kansas, but it is a profession that could be supervised by licensed anesthesiologists. So you can be an MD or DO and be a licensed anesthesiologist that could have supervisory role over anesthesiology assistants. At this time, in the state of Kansas, anesthesiology assistants are not a licensed profession in this state. They are licensed in other states, but we spent 3 days in the Senate Public Health Committee having hearings about this specific issue. And for 3 different years, the AAs have come and asked to be licensed profession from a legislative standpoint, and the legislature so far has said, no, it is not at the same level of the nurse anesthetists, the CRNAs, and so it is not a profession that we will license in this state. So what I do not want is the legislative process circumvented simply because the state of the Board of Healing Arts took an action this summer without a published hearing. They said they would have a discussion, but there was no published hearing. There was no opportunity for legislators or CNAs to testify against having that be approved. So I do not want us to allow that we will circumvent any professions that are not recognized as licensed professions in this state. Thank you, Madam Chair.
Certainly, we want to ensure that the legislature is legislating policy changes, and that's a discussion that we continue to have in, for instance, our Rules and Regs Committee that we will be looking at and possibly looking at later in this committee as well. So with that then, and thank you for bringing me up to date on testimony that occurred while I was out of the committee meeting room. And with that, I think I had a question also pending to Mr. Abbott, the reviser.
Thank you, Madam Chair. So we would be talking again about the same subsection H. The way it is written in current law, and the amendment would not change this, in my opinion, is very broad to apply to any healthcare professional licensed in good standing in another state. The clarifying exclusion refers only to not recognizing a profession that is not authorized by law. I do not read that to require licensure under Kansas law, so I think the situation that Senator Baumgartner is describing of a profession that is authorized by statute but not required to be licensed could be included in that subsection as it is currently written.
Could you repeat that again? Authorized by statute but not required to be licensed? Is that what you were saying?
Correct.
Thank you. The bill then is currently written would allow, if you're authorized by statute to operate here but not required to be licensed, you would be allowed to practice if the bill were to become law during the time that the bill is in effect, once it's become law.
Madam Chair, I think that's an accurate statement, and to clarify, that is the current state of that statute. It's expired, but that was the state of the law while that statute was in force and effect.
So does the bill or the amendment change the current status of that law? Mr. Abbott?
On that particular point, no. I mean, of course, the bill would renew the provisions of that statute for this time period that you're contemplating, but on that point, no, there would be no change.
Thank you. It's Senator Baumgartner.
Thank you, Madam Chair. And the reason this is the sticking point now is because of the Board of Kansas Board of Healing Arts action that they took this summer. They took this action this summer. And so that is why we're having this discussion now. That's why our Public Health and Wellness Committee had 3 days of hearing last week on this.
Thank you. And then it's perhaps an issue that will continue to be brought up in that committee. I'm not certain. I don't serve on that committee and haven't talked to the chair, but it might then be addressed in that committee as well. Yes, Senator Baumgartner.
The issue is, right now, AAs are not licensed to practice in the state of Kansas, and the no action is an action. So the legislature has chosen for 3 years in a row not to award that a licensed status, simply because the training that is required for anesthesiology assistant is significantly different from that of a CRNA, a certified nurse anesthesiologist. They often are presented as being identical. They are not. A certified nurse anesthesiologist must have X number of years of critical care. First of all, they're already licensed registered nurses, but they then must have multiple years of critical care, ICU care, before they can even apply for the CRNA program. So they have had years of independent work in ICUs, neonatal ICUs, cardiac ICUs, emergency rooms, etc. To be an anesthesiology assistant, you must have a bachelor's degree. And then you get that training. So we do not want folks that are not recognized as licensed professionals in our state to start practicing simply because they've been licensed somewhere else. Other states have lower standards than Kansas.
Thank you, Senator, and understand and appreciate the concerns, but other questions about the motion in front of us? Yes, Senator Gossage.
I want to echo the statements as Vice Chair of the Health Committee of what we have heard and the concerns that she shares. Thank you, Madam Chair. I do have a question for clarification, if I could, for the reviser. On page 5, it says in italics, nothing in this subsection shall be construed to authorize a healthcare professional to practice a profession that is not authorized by law in the state of Kansas. And then we indicate this included, or the paragraph that's to be inserted, and I'm not seeing the continuity here. Within 7 calendar days of that, they have to check in then with the regulatory body. I'm assuming that would be the Nurses Board or the Board of Healing Arts, depending on the professional. Subject to all rules and regulations applicable to the practice of the licensed profession in this state, and 2, considered a licensee. So it doesn't sound like they are giving temporary license to people who are not licensed in the state of Kansas, but to people who maybe were licensed in another state. That's the way I'm reading this, and could you correct me on that or clarify the revisor, please? Thank you, Madam Chair.
Sure. Mr. Abbott?
Thank you, Madam Chair and Senator. So the subsection as a whole would allow a person to practice in Kansas without a Kansas license or certificate or registration, subject to all these requirements. If they are licensed in good standing in their other states, and it's a profession that is authorized by law in the state of Kansas. It does not provide any mechanism for a Kansas license of any kind to be issued to a person practicing under those circumstances.
Senator Gossett, did you have further questions?
Yes, so then my follow-up question, given to what Senator Baumgartner has been sharing, is that in law, we have not codified the licensing of a CAA, but when the board found that they, under designation by a physician, could go ahead and practice, basically without being licensed, I think this is the concern, and I'm not seeing here that they can say they can be licensed if they haven't been.
Committee, I hear the concerns. We've all heard the concerns. I think we have a motion in front of us and a second, and we've had robust discussion, and perhaps it's an issue that is coming up in other committees in the Senate, and we need to get this issue to the Senate floor then to determine how best we want to proceed in this circumstance when we have this executive order expiring in 2 days from now. So with that, we have heard the motion and we have had discussion, and we will then vote on the motion to amend House Bill 2477. We don't have a title for this amendment, but the amendment that we've had in front of us that we're discussing. And I will ask then, all those in favor of the motion to amend, say aye.
Aye.
All those opposed, no. It seems that the motion passes and carries. We can ask then for a division with show of hands. Those in favor of the motion signify by raising your hand. And though I see 3 hands, and those opposed, raise your hand. Seeing 4 hands, then the motion fails.
Madam Chair.
And we are back on the bill. Yes, Senator Baumgartner.
Madam Chair, why don't we have the revisor see if he can find where to place if such profession is not authorized in the state of Kansas or is not authorized for licensure in the state of Kansas, find the appropriate place to put that statement in the amendments that were just brought to us.
Committee, that's a request for a voice amendment. If it's not too complicated for the revisor to put together a new amendment, that would be I'll call it the Corson offered amendment with the voice amendment to it by Senator Baumgartner, and then we would have a new amendment to be open to motions. Is that something, Mr. Abbott, you can put together while we stand at ease? Committee, with the revisor putting that together, we're going to pause working HB 2477 so they can get us a proper written amendment for us to look at. And we will then move on in the agenda to discussion and possible final action on Senate Bill 150. If we could get a bill brief from Mr. Thompson. Committee, this was a bill that committee heard last session about defining and prohibiting certain deceptive practices regarding certain advertising. So it's a Kansas Consumer Protection Act bill. And with that, I will invite Mr. Thompson to give us a bill brief and a quick reminder of the hearing.
All right, thank you, Madam Chair. Jason Thompson, Reviser, Statutes Office. So Senate Bill 150, you'll recall you heard on February 16th of last year. It was then referred to Fed and State and then referred back. So it is an exempt bill for purposes of the calendar. There are a couple of, nope, I take that back. I'm thinking of a different bill. There aren't any technical updates needed, so there are no dates, no statutes amended, no reason to update this, so it's good to go as is from last year. Essentially, it's got two new sections. The first requires a person engaging in legal advertisement to disclose certain things in their advertisement. There's a list of about 8 things there on the first page about what you have to disclose. And then if you violate the section, it is an unlawful and deceptive trade practice under the Consumer Protection Act, so it could be enforced by the Attorney General. Let's see, is there a criminal penalty for this one, or is it just the other one? I'm trying to remember. I know there's a criminal penalty in there somewhere. I'm not seeing it in section 1, so it must just be in section 2. But if I missed it, I stand corrected. The section 2 then is obtaining, selling, or disclosing certain protected health information when you're trying to solicit an individual for legal services. So this would be a prohibition of that practice. A violation of this section is, again, a violation of the Consumer Protection Act. In addition, it is also a knowing violation is a Class A non-person misdemeanor. So there's the criminal provision I was thinking of. And then there are certain exceptions about who this doesn't apply to. So that's the very quick overview of what's in there.
Thank you. Committee questions for the reviser? Seeing none, then we will open it up for discussion on the bill. Senator Corson.
Thanks, Madam Chair. So I raised a lot of these concerns. I don't know if folks remember when we discussed this bill during our last session, and I really do not support this bill, and I really would urge the committee not to either. And I have 3 main concerns. First and foremost, this legislation, I believe, is unconstitutional because it violates a guarantee of freedom of speech found in the First Amendment of the United States Constitution. And I want to be really clear about it that that's not my opinion. So I'm not offering that the committee should not support this bill because that's my opinion. It's the opinion of a conservative Republican-appointed United States District Court judge who looked at the identical law that was enacted by the West Virginia Legislature, and that judge determined that it was unconstitutional and that West Virginia was thus permanently enjoined and prohibited from enforcing it. That decision was issued on May 13th, 2021, so that's a new and that's a very important development for our deliberations. And when you read the opinion, the judge makes it clear that it's really not even a particularly close call with respect to constitutionality. It's a very high bar for a court to grant a motion for summary judgment. And so now it is true that if we do pass this bill and we are invariably sued, it is true that a federal judge in Kansas is not necessarily bound by that decision. So I want to be clear about that, but absent some very compelling reason, and I don't know what that reason would be, I think a judge is very likely to give great weight to a sister district court determination of the exact same issue. And if you look at the fiscal note that we got associated with this bill, the Attorney General's office pretty much acknowledges that we're going to face constitutional challenges if we enact this. The fiscal note says, enactment of the bill could be constitutionally challenged by individual lawyers, law firms, or legal organizations. The defense could be handled by the agency. However, it is possible that outside counsel would be needed to defend any lawsuit. And so when I read that, I'm just thinking about the amount of taxpayer money that we would have to spend defending this law in court over a number of years when it's already been found by another federal district court judge to be unconstitutional. So that's my first point. The second point is that when we heard testimony on this, we learned that there is already an 8-attorney office of the disciplinary administrator who is charged with investigating complaints, and that this conduct is already covered in the rules of professional conduct. So attorneys found to violate the rules of professional conduct, they face disciplinary complaints, investigations, reviews, sanctions, up to and including discipline by the Kansas Supreme Court, such as probation, sanctions, or disbarment. The committee received no testimony that this process was defective or that it was otherwise not working. And then my final reason that I don't support this bill is that there were no examples given that this is actually a problem in Kansas. I remember I specifically put the question to the proponents of could they point to examples of folks in Kansas who were harmed by this sort of conduct? And basically the response was that this was one of these cookie cutter bills that they're trying to get enacted in states all around the country. And so I would also pose this, because this is not really a Kansas solution to a Kansas problem. So again, just to wrap up, the combination of the unconstitutionality, the fact that we already have attorneys in the disciplinary administrator's office who are looking at complaints involving this sort of conduct, the amount of taxpayer money that we would have to spend over years defending this in court, and the fact that there's no issues of this kind of conduct in Kansas being problematic, I would just say that I don't support this bill. I don't think the committee should. You know, I don't love these sorts of ads that we've all seen, but, you know, I do love the Constitution, and I do love the First Amendment of the Constitution. So thank you very much, Madam Chair.
Committee, other discussion? Yes, Senator Pyle.
Thank you, Madam Chair. Could you have staff refresh us as to the proponents and opponents, any neutrals on this bill, since it was last February?
Ms. Nelson, could you refresh us on the conferees?
Okay, hello? Yeah. We had the Kansas Bar Association, which was an opponent. We had law offices of Slape and Howard was an opponent. Proponents were Kansas Chamber of Commerce, the U.S. Chambers Institute for Legal Reforms, the Kansas Trial Lawyers Association was an opponent. The National Federation of Independent Businesses was a proponent. The Kansas Association of Broadcasters was an opponent. The Kansas Medical Society was a proponent. And we had a Devon James Law Firm was an opponent.
Thank you. Committee, other discussion? Could you, Ms. Nelson, remind us, I think some of this language here in the bill is very similar to language and disclosures that we require of other business entities in the state of Kansas already in the Consumer Protection Act. And I'm trying to refer to it myself, but the disclosure that other business entities have to make. I thought that this mirrored some of that.
I do not recall that at this moment, but I'll look into it.
While you're looking at that, appreciate that. Wanted to just state that it has been found to stand up to scrutiny that we as a state have required businesses to make disclosures that provide the consumers additional information. Speaking regarding the regulation of attorneys, that is a different subject than what this bill addresses. So the ethical violations that the profession of attorneys may look at is different requirements, different standards, different than what this bill proposes. So, which is why we heard the proponents testifying in favor of the bill. So with that, we will look again for just a few moments, give Ms. Nelson a few moments. I think I recall during some of the hearing last time when we heard this, I read the particular language back to one of the opponents who was testifying, and now I myself cannot locate it.
Okay, so I'm looking at the testimony of Carrie Silverman on behalf of the U.S. Chamber Institute for Legal Reform. There is testimony, I just had it, it says SB 150 also prohibits 3 of the most common deceptive lawsuit advertising practices. These are practices that if used by any other type of business, they would likely result in government enforcement actions and class action lawsuits. They include prohibiting an ad from being presented as a medical alert, health alert, consumer alert, or public service announcement, which it is not, prohibiting an ad from displaying the logo of a government agency in a manner suggests the ad is affiliated or sponsored by that agency, and prohibiting use of the term recall in lawsuit ads or website names when referring to a product that has not been recalled.
Thank you. And I think I recall that we heard testimony that sometimes in the advertising, it's suggested that the product involved has been the subject of a recall, and just to make more disclosure and transparent about what the advertisement is about, who it's coming from, and whether it is part of a recall or not. I think with seeing no further discussion from the committee members, do we have a motion on the bill? Yes, Senator Baumgardner.
Madam Chair, I move we pass out Senate Bill 150 favorably.
Thank you. Second, Senator Wilborn.
I apologize, Madam Chairman. I did have an amendment
to
the bill. I apologize.
I will retract my motion.
Thank you, Senator. Go ahead, Senator Wilborn.
Yes, I have a simple amendment. It has to do with, on page 2, just ads other than legal services performed by a pro bona fide nonprofit provider or a pro bono legal services, and I'll let Jason further explain the detail. It would be on page 2, line 12, at the end of the sentence, for legal services.
Mr. Thompson, can you explain?
Yes, thank you, Madam Chairperson. Jason Thompson again. This would simply add an exception for those who are advertising pro bono services. They would not be subject to the requirements of the Act.
Committee discussion on the amendment? Seeing none then, is there a motion on the amendment?
Yes, Madam Chair, I would like to move the amendment.
Is there a second? Senator Baumgardner. Discussion on the motion, committee? Seeing none then, all those in favor of the motion to amend Senate Bill 150, say aye.
Aye.
Those opposed, no. The motion passes. We're back on the bill. Committee, any other amendments or discussion? Seeing none then, is there a motion? Senator Baumgardner.
Thank you, Madam Chair. I move we pass out Senate Bill 150 as amended favorably.
Yes, is there a second? Senator Bowers, thank you. Committee, you have heard the motion. All those in favor, aye.
Aye.
All those opposed, no. The motion passes. The bill, Senate Bill 150 as amended, will be reported out favorably. Thank you. Yes, Senator Haley would like his no vote recorded, and Senator Corson will as well. Committee, then, we will ask Mr. Abbott if he is ready with the amendment for House Bill 2477.
Madam Chair, I believe copies are being made, so if you could give us just a couple minutes.
Committee, we will stand at ease. Committee, we do also have on the agenda for today discussion and possible final action on HB 2109. However, given the late hour and the press of the business of HB 2477, we will move HB 2109 to a different date. Thank you. While we're And we now have the amendment down to a one-sentence amendment, and due to the press of time, I'd ask the committee to hear from Mr. Abbott, who can explain what the one sentence is while we are waiting for the printed sentence and amendment to come out. Mr. Abbott?
Thank you, Madam Chair. So the amendment would be the same as the Corson amendment everywhere except for on the final page. This is the insert of KSA 48965, the section that authorizes temporary emergency licenses by the State Board of Healing Arts. And the amendment would be to add a subsection C and move the expiration date down to D, and that sentence would be, no temporary emergency license shall be issued to practice a profession unless such profession is required by law to be licensed, certified, or registered in the state of Kansas.
Thank you. Could you state that sentence one more time?
Yes. It would be, no temporary emergency license shall be issued to practice a profession unless such profession is required by law to be licensed, certified, or registered in the state of Kansas.
Thank you. Committee, we will wait for the printed version of the amendment so we're all clear on what the amendment states. Committee, we can have a discussion about the amendment while we're waiting. Senator Haley?
Thank you, Madam Chair, and let me, I know it hasn't been moved yet or seconded. I've been around for a while. I've never seen amendments on the fly like this in the middle of committees, and I can't ever remember this happening before. But I do understand the exigency here, and that we have to act on this bill, and that includes amendments. I did not support the previous one offered by my colleague, our friend, Senator Corson, and will not be supporting this amended version only because of the time. We are a bicameral legislature. We do have to confer with our colleagues in the House. We are running out of a certain amount of time, and to have new measures considered that the House has not reviewed or acted upon, if they do not concur with the amendments that are adopted here or by the Committee of the Whole, will cause our time to lapse. It is for that reason strictly procedural, both for this amendment that's being offered in an unprecedented manner, again, I have to add, and for the previous one as offered by Senator Corson, that I will not be supporting it. However, should it pass muster with the House, if they concur, no problem. If it doesn't, I will support this Senate position on the conference committee with yourself, Madam Chair, and Vice Chair Wilburn. Thank you.
Want to make clear that it is perfectly appropriate to make amendments in committee as issues are discussed and deliberated, and we're doing our work here in committee, so there is nothing procedurally out of order in how we are making amendments here. The amendment was voted down. We will have a brand new amendment. If there is a motion on it, we will act on that as well. And though the House did or did not consider these amendments, we as the Senate are free to make our amendments and have our debate and our considered discussion, and to put it to the Senate as a whole if this bill passes out of committee. So I want to reiterate that though we are taking this bill up today with a certain timeline, if we don't act by Friday, there is nothing procedurally unusual or improper in the way we are proceeding. With that, then, do we have a motion on the amendment? Senator Baumgardner.
Thank you, Madam Chair. And I'm very disappointed that my colleague, because now it's new and improved. I was certain we would pull you in with that, but based on your comments, I move that we take the amendment that had been passed out originally from Senator Corson, and we add the sheet that we have before us, because we need those two parts.
Thank you, Senator. I'm needing some clarification. The amendment originally offered by Senator Corson had failed.
It did.
The new amendment is the language of that amendment with the one-page addition that just got passed out and the language in blue underline. Is that the amendment that is being moved?
It's a substitute. We would substitute what we did originally vote down, which was presented to us by Senator Corson, in addition to this sheet.
Well, the motion failed, so it's not a substitute motion. It's a new amendment and a new motion. So,
We'll go with the new. I thought that's what I had said before.
sorry.
I know, my voice is still straining with my voice. So we will take what was originally presented, and it is a 5-piece document, and we will add this additional sheet. And it's just the sections that are C and D, that renumbering or relettering, if you will. That is the motion.
Committee, is there discussion on the motion? Seeing none, do we have a second? Do I have that right? You've moved your amendment and we need a second. Do we have a second? Senator Gossage?
If I could just clarify the motion.
Sure.
It would include, we would then be adding Senator Corson's amendment plus this amendment, so amending Senator Corson's original amendment, correct?
Correct.
Then I second that.
Okay. Any discussion? Seeing none, then all those in favor of the motion say aye. All those opposed, no. The motion passes. We're back on the bill. We have one other amendment, committee, that I think Senator Wilborn has to offer.
Thank you, Madam Chair.
Shorter than the last.
Yes, thank you. I hope so. This amendment simply puts the date out to March 2023. Let me see that.
Can you hold a second? This might have changed.
I'm sorry. Hold on a second.
Okay, Madam Chairman, the amendment we have before us moves the date back to March 31st, 2023. However, based upon joint negotiations with the House, that moves to January 20th of 2023. So my amendment is January 20th, 2023.
Committee, the amendment before you then to change the date is to change the date in the balloons you have there to January 20th of 2023. In the balloons only. Senator Powell, did you have a question?
The dates on the balloon that I've been given are March 31st, 2023.
Correct, and we have a voice change to what's written in the balloons to make it January 20th, 2023.
The same date. Note that.
Thank you, Madam Chair. To clarify, I was given that date late, and this changed all the dates that affect this bill to January 20th, 2023.
Committee, any discussion on the amendment? Seeing none, then do we have a motion? Senator Wilborn?
I so move.
Do we have a second? Senator Gossage. Committee, you've heard the motion on the amendment to change the date to January 20th, 2023. All those in favor, aye. All those opposed, no. The motion carries. Committee, we're back on the bill. Is there a motion? Yes, Senator Baumgardner.
Chair, are you ready for a motion to pass this out favorably?
Yes.
Okay. I move that we pass out House Bill 2477 as amended favorably.
Is there a second? Senator Gossage. Committee, all those in favor say aye. All those opposed, no. The motion carries and the bill will be reported out as amended favorably. Committee, thank you for your diligent work today, and for those following along online, we appreciate you hanging in there with us as well, and we are adjourned.